So you sent us this stack of judicial findings, and I have to say, reading through these high-stakes court rulings is, well, it's a masterclass
In what way?
in how incredibly tiny legal definitions can end up dictating these massive life outcomes. We're talking murder convictions, child custody, even, whether someone gets to keep their home.
It's absolutely true. People often dismiss legal language as just bureaucratic jargon, right?
Yeah.
But in reality, these definitions are the very hinges that liberty and security swing on. So our mission today is to sort of distill the core principles from these complex rulings. And in doing that, highlight the critical role of procedural fairness and, maybe more importantly, the rigorous testing of evidence in our justice system.
So for you, the learner, this is basically the shortcut. This is how you understand the wiring diagram that's working underneath the headlines.
Yeah.
We've picked out 3 pivotal areas to unpack today.
And they all center on this power of specificity and definition.
It's exactly. First, we're going to get into the really intricate rules about hearsay testimony in a huge homicide case. Then we'll look at what specific grounds actually means when a public housing authority tries to evict someone.
And finally, how the courts legally define when an offender is a danger to the community.
Okay, let's unpack this. I think we have to start with the case that really just shook the evidence rules to their core. State v. Corbett.
A very highly publicized case.
Deeply publicized, from 2015, involved the death of Jason Corbett in North Carolina. He was killed by his wife, Molly Martens Corbett, and her father, Thomas Martens. And get this, her father was a retired FBI agent.
Right, and that detail is important. So the initial trial, it results in second-degree murder convictions. They get sentences of 20 to 25 years. Their claim was self-defense. They argued they were protecting Molly from abuse. But the forensic evidence, it was just devastating.
How so?
Jason Corbett suffered approximately 12 blows to the head, so they were convicted back in 2017.
But, and this is the key, the legal story did not end there.
Yeah.
In 2021, those convictions were reversed. Essentially, they got a new trial, which then led to a plea deal in 2023 for voluntary manslaughter.
And the reversal wasn't about the facts, not really. It was all about serious errors the original trial court made in excluding evidence the defense wanted to use.
And the core of that error, it seems, involved this incredibly complex world of child hearsay.
Exactly. The first key error revolved around excluding statements that were made by Jason's 2 young children, Jack and Sarah.
Where were these statements made?
To trained professionals at a place called Dragonfly House, which is a child advocacy center. The defense wanted these statements admitted under a very specific hearsay exception for statements made to doctors for, medical diagnosis or treatment.
Okay, wait. If the kids were talking to forensic interviewers, not like their pediatrician, how does that count as medical diagnosis? That seems like a stretch.
And that's the subtlety the higher court really hammered home. They found the trial court got it wrong because the focus shouldn't be on what the children subjectively understood.
I see.
It's about the objective circumstances around the interview. Dragonfly House uses trained professionals. They explain the importance of being truthful, and these evaluations often happen right alongside a physical exam.
So the context itself makes it medical.
The context, objectively, showed the statements were made for the purpose of diagnosing the children's well-being after a violent event.
Right.
And that meets the high reliability standards of that exception.
And the content of what they said was obviously critical to the defense's claim that this was an abusive home.
Precisely. Jack said that Jason physically and verbally hurt my mom. He mentioned punching, hitting, pushing, and Sarah described Jason getting really angry over, tiny things like a light being left on.
Details that paint a very different picture.
A picture of domestic discord that the defense absolutely needed for their self-defense argument.
So that's one type of statement that was wrongly kept out. But there was a second, completely separate error about the children's statements, right?
Yes. This one concerned comments they made even earlier to a DSS social worker. The defense tried to get these in under what's called the residual hearsay exception.
Which is what exactly? Like a catch-all?
It's essentially a legal backdoor for trustworthy evidence that doesn't fit neatly into any of the other boxes.
And this is where the system starts to question the kids' motives.
This is where the original trial court really abused its discretion. It found the statements untrustworthy. It claimed the children lacked personal knowledge, and this is crucial, that the children were motivated to lie.
Motivated to lie to do what?
To preserve their custody environment with their family.
Wait, but if the court rejected that idea, Isn't that essentially saying we have to presume children are always telling the truth in these situations?
Not always, but the higher court's point was that the trial judge couldn't just presume a bad motive simply because what a child says might affect custody. They looked closely at the record. They found the kids' statements contained clear, firsthand knowledge of things they saw or heard.
For example,
Jack reported seeing his dad curse and hit his mom. Sarah described seeing her dad smack her mom across the face. This wasn't something they heard from someone else. It was firsthand information.
so the ultimate finding was that keeping these statements out was prejudicial.
Prejudicial enough that it deprived them of fully presenting their self-defense claims. And that's what led to the reversal.
Okay, let me just pause there and synthesize for a second. The Martens' convictions were overturned because the court failed to see two separate, distinct legal paths
The medical diagnosis exception and the residual exception.
that made these potentially favorable statements from the children admissible.
That's the perfect synthesis. But there's a third key evidentiary error that is, I think, probably the most conceptually difficult. It's related to the father's own testimony, Tom Martens.
What did he try to say?
He tried to testify that during the fight, he heard his daughter, Molly, yell out, "Don't hurt my dad."
And that, too, was excluded in the first trial. It sounds like textbook hearsay. She said it out of court. He's repeating it in court.
And that exclusion was an error, a huge one, because the statement was not hearsay at all.
How is that possible?
This is where the definition is pure power.
Okay, help me nail this down. If the law doesn't care whether Molly was telling the truth, if Jason was actually hurting Tom in that moment, why let it in at all?
Because the law isn't focused on the statement itself, it's focused on the effect it had on the listener, on Tom Martens.
I see.
It was offered only to illustrate his subjective state of mind, his fear for his own safety, the urgency of it all, and that was highly relevant to whether his claim of self-defense was reasonable.
So it doesn't matter if what she yelled was true or false.
Irrelevant.
Yeah.
What matters is that Tom heard it and reacted based on his reasonable belief. It's like a witness testifying, "I saw a red flashing light," not to prove the light should have been red, but to explain why the driver slammed on the brakes.
So the key pivot point is the listener's perspective, not the speaker's objective truth.
Wow.
That's a powerful lesson in how the law approaches subjective belief when deadly force is on the table.
A huge lesson.
We just saw how these tiny definitions in evidence rules can literally overturn a murder conviction. Now let's see how that same obsession with precision applies in administrative law. A totally different world.
Right.
We're talking about someone trying to keep their home. Let's transition to Raleigh Housing Authority v. Winston.
This case is a deep dive into due process, into the fundamental right to clarity when it comes to public regulations, specifically for a public housing tenant facing a summary ejectment.
Which is just a legal term for a quick eviction.
Just a quick eviction. And the federal regulation here is crystal clear. A termination notice must state specific grounds for termination.
So the Raleigh Housing Authority, they send a notice. And the reason for eviction is listed as inappropriate conduct, multiple complaints, and then it just quotes the general lease provision, about not disturbing neighbors' peaceful enjoyment.
Right.
I mean, that sounds reasonably clear on the surface. What was the legal problem? Why did that notice fail?
The problem is baked right into that word specific. The court analyzed the plain language. Specific means clearly defined or identified. Grounds means the factors forming a basis for action.
So the housing authority gave the rule, but they never gave the offense.
You've got it. They identified inappropriate conduct, but they completely failed to say what that inappropriate conduct actually was.
They didn't give any examples.
Exactly. Merely quoting the general lease provision was held to be fatally deficient on this record. Think about it. If you're the tenant and all you know is inappropriate conduct, multiple complaints, how can you possibly prepare an effective defense?
You can't. You don't know if the complaint was about loud music on a Tuesday or an argument in the parking lot last month or, a pet violation.
The notice failed to identify the specific conduct. It failed to identify the factors justifying the eviction.
So the housing authority thought they were being clear, but this one small lack of detail, the failure to state the specific facts, it cost them the eviction.
It did. It resulted in a reversal and a dismissal of the case. Specificity is protection for the tenant.
It's the ultimate check on arbitrary bureaucratic power.
Absolutely. Due process demands that before you lose something as fundamental as your housing, you must know precisely what you are accused of doing.
That brings us to our final deep dive, where legal definition faces a different kind of tension. We're talking about statutory interpretation in the criminal justice world in State v. Fuller. And here, the whole case revolves around defining a single phrase, a danger to the community.
Right. This involved a defendant who was convicted of secret peeping. And critically, secret peeping is not an offense that automatically triggers lifetime sex offender registration.
It's not automatic.
No, registration is only required if the trial court makes an explicit finding that the person is a danger to the community.
And in this case, the judge did mandate that he had to go on the sex offender registry for 30 years. Now, the defense argued that danger to the community has to be explicitly tied to the likelihood to reoffend.
Right. They wanted the state to present a formal statistical risk assessment. They mentioned tools like the Static 99, which is a common instrument used to predict recidivism.
Is that what happened?
No. And what's fascinating here is that the higher court affirmed the registration order based on the nature of the crime itself, not strictly on a separate statistical assessment. They established that danger can be shown by the specific, egregious facts of the offense.
That sounds like a really subjective judgment call, which is exactly what the defense was trying to avoid by demanding a hard number, a statistical tool.
It does, but the court laid out its reasoning.
What specific facts did they use to justify this 30-year mandate?
They focused on four main elements that, for them, define the crime as dangerous. First, the defendant's willingness to take advantage of a close personal relationship. He was living in the victim's home.
An extreme abuse of trust.
Total abuse of trust. Second, the use of a sophisticated, meticulously executed scheme that was designed to avoid detection. He was moving a hidden camera between the bedroom and the bathroom.
Wow.
Third, the extended duration. Images were obtained repeatedly over several months. And fourth, just the repeated, calculated invasion of privacy.
So the court essentially said that the meticulousness of the crime, the sophistication of it, combined with that abuse of trust, that was enough to define him as a danger.
Yes.
They didn't need a formula to calculate his future risk. The crime he just committed was proof enough of his dangerous capabilities.
That is the precise legal nuance. While a dissenting opinion argued that this separates the registration from the real question of recidivism, the majority affirmed that these specific, detailed facts about the methodology and the harm of the crime were sufficient.
And the reasoning was?
They reasoned that the trial court was entitled to make this ultimate finding based on the evidence presented, which reflected the ease and the planning he'd use if he were to do it again.
What stands out to me across all three of these rulings is just how dependent our lives and liberty are on the meticulous application of these definitions. We went from a child's out-of-court statement determining if a murder conviction holds to whether an eviction notice includes the factors of a violation, all the way to defining danger, not by predicting the future, but by analyzing the meticulousness of a privacy invasion.
And I think the critical takeaway for you, the learner, is that in law, definitions are power. These rulings show how liberty, custody, housing, they all turn on these seemingly small distinctions.
Like whether a statement is offered for its truth or for someone's state of mind.
Or whether a bureaucratic notice included the right factors to form a basis for action. These aren't just details, they're everything.
And if we connect this one last time back to the bigger picture of the Corbett case, remember Tom Martens' testimony. Hearing his daughter yell, "Don't hurt my dad," it was only admissible to show his subjective fear.
Right. Only to prove the reasonableness of his belief, totally separate from the objective truth.
This raises a really important question for all of us to mull over, one that lives right at the heart of self-defense law.
Which is,
when the law requires a jury to assess the reasonableness of a subjective belief, the belief of imminent danger, how closely can a court, or any of us, truly separate that required subjective belief from the objective truth of what was actually said or what was actually happening? It's a tension the courts manage every single day.